Hello everyone, welcome back to our pre-review class for corporation law. So for this video, we will discuss about the board of directors or trustees and officers. So let's start with the doctrine of centralized management under section 22, which provides that unless otherwise provided in this code, the board of directors or trustees shall exercise the corporate powers, conduct all business, and control all properties of the corporation. So when you say centralized management, ibig sabihin, yung board of directors and trustees, sila yung may hawak sa management, no? Sila yung may power, no, to they have the corporate powers to conduct all business, no, and to control all the properties of the corporation. Naka-centralize sa kanila. Unlike kasi sa partnership, 'di ba, sa partnership kung wala silang manager doon sa kanilang articles of partnership or partnership agreement, kahit kanino sa kanila are agents of the partnership. And each one of them can enter into contract, no, and can bind the partnership. But here, for corporations, nakacentralize yan sa tinatawag nating board of directors or trustees. Example, the board of directors may authorize through a board resolution another person to act for the corporation. Kaya lahat ng mga actions ng corporation, kailangan dumaan talaga yan sa board of directors. Kung may papagawa sila, kailangan i-authorize talaga ng board of directors. Otherwise, any actions that are not authorized by the board of directors are actions that are beyond powers of the corporation or tinatawag nating ultra vires, no? Outside, no, authority. Corporations vested with public interest. Corporations covered by Section 17.2 of Republic Act Number 8799, otherwise known as the Securities Regulation Code, namely those whose securities are registered with the Commission, corporations listed with an exchange or with assets of at least 50 million pesos and having 200 or more holders of shares with at least 100 shares of a class of its equity shares. So ito do yung mga corporations vested with public interest. So kung ganito nakalaki yung kanilang assets at saka holders of shares and number of shares, then magiging imbued na siya with public interest. Banks and quasi-banks, NSSLAs, pawn shops, corporations engaged in money business, service business, pre-need, trust and insurance companies, and other financial intermediaries. Other corporations engage in business vested with public interest similar to the above, as may be determined by the Commission after taking into account relevant factors which are germane to the objective and purpose of requiring the election of an independent director, such as the extent of minority ownership, type of financial products or securities issued or offered to investors, public interest involved in the nature of business operations, and other analogous factors. So, sino yung independent director? He's a person who, apart from shareholdings and fees received from the corporation, is independent of management and free from any business or other relationship which could reasonably be perceived to materially interfere with the exercise of independent judgment in carrying out the responsibilities as a director. So, term of office for director, 1 year. For trustee, 3 years. Each director and trustee shall hold office until the successor is elected and qualified. A director who ceases to own at least 1 share of stock or a trustee who ceases to be a member of the corporation shall cease to be such. Kasi meron tayong requirement na dapat pala yung director is at least a stockholder of 1 share, no? Dapat member ka talaga ng corporation para maging director ka. So what is business judgment rule? The acts and contracts entered by the board within the power conferred upon it are binding on the corporation, and courts will not interfere unless such acts or contracts are so unconscionable and oppressive as to amount to wanton destruction of rights of the minority. So, generally, lahat daw ng acts and contracts na pinasok ng mga board of director within power conferred upon it, binding siya sa corporation. Unless na lang ma-prove na yung mga acts na yan are so unconscionable and oppressive, no? As to amount to wanton destruction of rights of the minority stockholders. So kapag yung acts is very, ano na siya, unfavorable on the part of the minority stockholders, then pwede nilang i-question no, yung acts and contracts entered by the board. Questions of policy or management are left solely to the honest decision of officers and directors of a corporation, and the courts are without authority to substitute their judgment for the judgment of the board. The board is the business manager of the corporation, and so long as it acts in good faith, its orders are not reviewable by the courts or the Securities and Exchange Commission. So siguro, ang remedy lang niyan is kung may abuse of authority, no? Or may bad faith, evident bad faith on the part of the board of directors. So that's the time that you can question it. But generally, kung wala namang anything that is abusive or unconscionable or oppressive, then mag-apply talaga yung business judgment rule na the court will really respect the decision of the board of directors. Corporate officers and directors, absent self-dealing or other personal interest, shall be shielded from liability for any harm to the corporation resulting from their decisions if such decision lie within the powers of the corporation, the authority of management are reasonably made in good faith and with loyalty and due care. So ibig sabihin, kunyari, meron silang actions na nag-result into losses on the part of the corporation. So it doesn't mean na kung nagka-loss yung corporation dahil sa decision ng board, it doesn't mean that they are liable for that. Kasi we have this business judgment rule, no, na that is only part of their duty for as long as yung acts and contracts na in-enter ng board are within the power conferred upon them, no? Hindi yung ultra vires acts, no? Hindi yung unauthorized acts, basta within their powers. Kasi yung losses naman is a result naman yan sa operation, no? Hindi lang talaga yan solely the result of the decision of the board, no? Pwede ding nandoon sa pagmamanage, no? Sa mga employees, etc. So, generally, hindi talaga sila liable, no? For any unfavorable outcome sa kanilang decision. Kasi nga, we have this business judgment rule. And yung decisions nila, generally, hindi reviewable by the courts. So, election of directors or trustees, dapat in person, through a representative authorized to act by written proxy. So, pwede pala proxy through remote communication or in absentia when so authorized in the bylaws or by a majority of the board of directors, the stockholders or members entitled to vote. A stockholder member who participates through remote communication or in absentia shall be deemed present for purposes of quorum. Corporate officers, president must be a director, treasurer must be a resident of the Philippines. So meaning to say, a treasurer need not be a director, basta resident lang ng Pilipinas. Secretary must be a citizen and resident of the Philippines. Such other officers as may be provided by the bylaws. Compliance officer if the corporation is vested with public interest. The same person may hold 2 or more positions concurrently, except that no one shall act as president and secretary or as president and treasurer at the same time unless otherwise allowed in this code. So, pwedeng ikaw ay at the same time treasurer and secretary. Pero hindi pwedeng ikaw ay president, ikaw din yung treasurer. Hindi din pwede na ikaw yung president, ikaw yung secretary. Okay? Disqualification of directors, trustees, or officers under Section 26. Number 1, convicted of a final judgment of an offense punishable by imprisonment for a period exceeding 6 years. So kung na-convict ka tapos yung penalty mo more than 6 years, you are disqualified no, to become a director. Okay? Trustee or officer. For violating this code, kung meron kang violations under the Corporation Code, or for violating Republic Act number 8799 or the Securities Regulation Code. Second, found administratively liable for any offense involving fraud acts kapag napasok ka sa mga fraudulent transactions and na-prove na talagang liable ka administratively, then you are disqualified. And by a foreign court or equivalent foreign regulatory authority for acts, violation, or misconduct similar to those enumerated in paragraphs A and B above. So, meaning to say, even if you have committed the crime or any act, no, violative act outside the Philippines, kung merong foreign order from a foreign court or foreign regulatory authority, then that will constitute a ground for your disqualification. So hindi necessary na dito lang sa Pilipinas na commit, no? Pwedeng doon ka na convict sa ibang bansa. Removal of directors or trustees under Section 27, it must be by a vote of the stockholders holding or representing at least 2/3 of the outstanding capital stock, or if the corporation be a non-stock corporation, by a vote of 2/3 of the members. Ibig sabihin nito, kung meron kayong gustong i-remove na director or trustees, mag-call kayo ng stockholders meeting. Okay? Magpatawag ng stockholders meeting and then kuha kayo ng vote doon. Dapat 2/3 of the outstanding capital stock. Okay? That is for stock corporation, stock corporation. But for non-stock, 2/3 of the members. Such removals shall take place either at a regular meeting of the corporation or at a special meeting called for the purpose. Okay? Called by the secretary or the stockholder member of the corporation signing the demand. Notice of the time, place of such meeting as well as of the intention to propose such removal must be given by publication or by written notice prescribed in this code. Removal may be with or without cause. Removal without cause may not be used to deprive minority stockholders or members of the right of representation to which they may be entitled. The Commission shall motu proprio or upon verified complaint and after due notice and hearing order the removal of a director trustee to elected despite the disqualification or whose disqualification arose or is discovered subsequent to an election. Okay? What happens to the shareholdings of a removed director? The law says that he remains to be a stockholder. Okay? Hindi mawawala yung kanyang share sa corporation. Hindi lang siya mai-elect as director. Matatanggal siya as director. Since the authority to elect corporate officer rests with the board, there is a correlative authority to remove the corporate officers. Kasi iba yung corporate officers, iba din yung board. Yung corporate officers, sila yung president, vice president, sila yung secretary, treasurer, yun sila. So, like tayo dito. Yan. Diba? President, treasurer, secretary, compliance officer with respect to corporations vested with public interest, and such other officers as may be provided by the bylaw. So, paano yan sila i-remove? Kasi sa director, kailangan ng 2/3 votes for them to be removed. But for corporate officers, yung board of director, pwede na sila na lang ang mag-remove kasi sila naman yung nagbigay ng authority. Okay? Vacancies in the office of director, how do we treat if merong vacancy? Okay? If you feel siya by the vote of at least a majority of the remaining directors or trustees if still constituting a quorum. So sila lang din within the directors ang magboboto kung sino yung ipapalit nila. Otherwise, vacancies may be filled by the stockholders or members in a regular or special meeting called for that purpose due to the expiration of the term. Okay, mag-end na yung term, removal, due to an increased number of directors or trustees when there is no quorum. So, pwede kayong mag-call ng stockholders meeting para mag-fill in ng vacancy. Liability of director, trustees, or officers. General rule, di ba sabi natin, hindi sila liable sa acts and contracts entered into by the board of directors for as long as they are within their corporate powers. But there are instances wherein the board of directors, trustees, or officers become liable. What are those? One, when they willfully and knowingly vote for or assent to patently unlawful acts of the corporation. Of course, take note that the corporation can only exercise powers vested under the law or those implied or incidental thereto. So, merong limited power yung corporation, yung corporate existence. So therefore, kapag nag-perform sila ng unlawful acts, then ibig sabihin that goes beyond the power of the corporation. So in that case, magiging liable yung mga board of directors who voted for it, who assented to it. When they are guilty of gross negligence or bad faith in directing the affairs of the corporation. Generally, hindi naman natin charge na liable yung mga board of directors for a mere errors of judgment. No? Kung meron lang error talaga sa judgment, tsaka kung merong losses sa company, kasi normal naman talaga yan, no, na merong losses. Pero kung merong gross negligence, yung talaga, disregard of the diligence required under the circumstances, or kung merong bad faith in the conduct of the affairs of the corporation, then that's the time that the director, trustees, or officers will become liable. But of course, you should prove it na hindi yan pwede na sabi-sabi lang, na chismis, no? Kailangan talaga yung i-prove. When they acquire any personal or pecuniary interest in conflict with their duty as such directors or trustees. So, for example, meron ng conflict of interest, no? Yung director, meron siyang company ngayon na in conflict with the corporation. So, maka-question na yung kanyang commitment to the corporation and loyalty to the corporation. Baka hindi niya ibigay yung project or anything na transaction na favorable supposedly for the corporation, hindi niya ibigay sa corporation kasi kukunin niya for his personal interest. So, in that case, pwede na siyang maging liable. When a director has consented to the issuance of watered stocks or who, having knowledge thereof, did not forthwith file with the corporate secretary his written objection thereto. When the director, trustee, or officer has contractually agreed or stipulated to hold himself personally and liable with the corporation. When the director, trustee, or officer is made by specific provision of law personally liable for his corporate action. Dealings of directors, trustees, or officers with the corporation. The contract is voidable. The contract is between the corporation, director, trustee, or their spouses or relatives within the fourth civil degree or consanguinity or affinity. So kapag merong contract, yung director tsaka yung corporation, or relative nila or spouse nila within the fourth civil degree, parang unay ba? Nga sila yung nangontrata sa sarili nila corporation. So, what the status of the contract is voidable. Unless the following conditions are present: the presence of such director or trustee in the board meeting in which the contract was approved was not necessary to constitute a quorum for such meeting. So, kung hindi kailangan yung presence niya to approve it, the vote of such director was not necessary for the approval. The contract is fair and reasonable under the circumstances. In case of corporations vested with public interest, material contracts are approved by at least 2/3 of the entire membership of the board, with at least a majority of the independent directors voting to approve the material contract. And in case of an officer, the contract has been previously authorized by the board of directors. Where any of the first three conditions set forth in the preceding paragraph is absent, in the case of a contract with a director or trustee, such contract may be ratified by the vote of the stockholders representing at least 2/3 of the outstanding capital stock or of at least 2/3 of the members. So para, di ba sabi natin voidable yung contract? Pero magiging valid siya kung present itong mga conditions. Pero what if hindi lahat ng conditions present? So kailangan mo ng ratification ng stockholders, 2/3, okay? Or 2/3 of the members kapag non-stock. Contracts between corporations interlocking directors. A contract between two or more corporations having interlocking directors shall not be invalidated on that ground alone, except in cases of fraud, and provided the contract is fair and reasonable under the circumstances. So, ibig sabihin nito, when you say interlocking directors, yung director ng kabilang corporation are also directors of the other of the corporation. Parang ganun ba? Interlocking. So, sabi ng batas, hindi daw yan ground to invalidate any contract entered into between the two corporations. Provided, hindi yan fraud at saka fair and reasonable yung contract na yan, no? If the interest of the interlocking director in one corporation is substantial, like 20%, and his interest in the other or in the other corporation is merely nominal, the contract shall be subject to the provisions of Section 31. Ito siya, diba? Voidable siya. So, kailangan yung conditions magiging present. Kasi, malaki yung, substantial yung kanyang shareholding doon sa isang corporation. So, kailangan na ma-meet yung conditions. But kung hindi naman, nominal lang both sides, then okay lang, no? Hindi siya invalidated. Hindi siya ma-invalidated, no? Provided hindi siya fraud tsaka fair and reasonable. Disloyalty of directors, doctrine of corporate opportunity, where a director, by virtue of his office, acquires for himself a business opportunity which should belong to the corporation, thereby obtaining profits to the prejudice of such corporation, he must account to the latter for all such profits by refunding the same, unless his act has been ratified by a vote of the stockholders owning or representing at least 2/3. So, ang ibig sabihin lang nito, kunyari, supposedly dapat yung transaction na yon is for the corporation. Pero, ikaw, nag-transact ka separately. So, ikaw karon ang nakakita o kwarta to the prejudice of the corporation. Kasi dapat kapag ikaw ay director, loyal ka, no? Wala ka dapat conflict of interest. Wala kang personal or outside interest. So, yun siya, no? So, you should account lahat ng profit, no? Na nakuha mo, no? I-refund mo yan sa corporation. Unless na lang, of course, nisugot rapod ang mga stockholders. Dapat 2/3, no? And take note that even if the director used his own funds para atong a venture, still, this provision is applicable. The director is required to account to the corporation all the profits by refunding the same to the corporation. Tests applied for the application of the doctrine. We have interest or expectancy test, which precludes acquisition by corporate officers of the property of a business opportunity in which the corporation has a beachhead in the sense of a legal or equitable interest or expectancy growing out of pre-existing right or relationship. Line of business test characterizes an opportunity as corporate whenever a managing officer becomes involved in an activity intimately or closely associated with the existing or prospective activities of the corporation. Murag ikaw na lang, nag-transact na ka sa imong sarili. So, wala na transaction ng corporation, di ba? Fairness test determines the existence of a corporate opportunity by applying ethical standards of what is fair and equitable under the circumstances. Mixed test, meaning the application of any two or all tests. So remember, interest or expectancy tests, line of business tests, fairness test, and mixed test. Executive management and other special committees, If the bylaws so provide, the board may create an executive committee composed of at least 3 directors. Said ko ay ito yung like sa board of directors, meron silang kanya-kanya na committee. Tinagtatlo yung members nila. Like committee on, ano yung mga example ng committee nila dyan? Mediation committee. Committee on, ano yung mga committee ng corporation? Basta meron, pwede sila mag-create ng mga committees, no? Within themselves. Pero ang idea ko lang is, for example, sa Sangguniang Panlalawigan, mga, ano sila, board members, di ba? Parang ganun lang naman yung concept. So, lahat sila board members, no? Then, may grupo-grupo yan sila. Meron silang committee on legislation, sila yung gumagawa ng mga ordinances, nagre-review ng mga ordinances, etc. May committee on education, committee on, yung mga ganyan. So, meron din ganyan sa sa corporation, committee din sila. So, kapag meron silang topic or meron silang agenda or item na i-approve, i-refer nila yan sa committee, no, for review. Okay? Okay, so that ends my discussion, no, for Board of Directors, Trustees, and Trustees. So, and their powers, no? How to convene them, ano yung, paano to remove, etc. So, next video will be for powers of the corporation. So, thank you for listening. See you in our next video. Goodbye.